Have you ever thought about this? What if a government could detain someone not for a crime they've already committed, but for one they might commit in the future? Well, that is the central idea behind India's National Security Act of 1980. So today, we're going to break down exactly how this powerful law is built, piece by piece, and how it actually works. Right. And here's the official purpose of the law, stated in one single powerful sentence. The phrase you really need to latch onto here is preventive detention. So let's unpack what that really means and why it's so key to understanding this entire act. So here's how we're going to tackle this. First, we'll cover what the NSA actually is. Then we'll get into the specific reasons someone can be detained. After that, we'll walk through the process step by step, look at the role of the advisory board, and finally, cover the ultimate limits on this power.
Okay, let's dive right in.
So, at its heart, what is the National Security Act? It all comes down to that one concept, preventive detention. This isn't like a normal arrest, where something happens after a crime. This is all about detaining someone to stop them from doing something the government thinks could be harmful. It's about prevention, not punishment. But of course, that raises a massive question, right? What kind of harmful act is serious enough to justify using this kind of power? Well, the law is actually very specific about the reasons or grounds for detention. The grounds are all laid out right there in Section 3 of the Act, and you can see they cover a really wide spectrum. It goes from huge national-level threats, like actions against the defense of India, all the way down to internal issues, like disrupting public order or cutting off essential services. And there are also specific provisions in there for foreigners. So who gets to make this call? Well, the power to issue these detention orders lies with the central and state governments. But, and this is critical, that authority can also be delegated down to the local level, and when that happens, it triggers a very specific chain of command. And this is where the first procedural checks really kick in. If a local district magistrate or a police commissioner issues an order, they can't just act alone. They have to report it to the state government immediately. The state then has just 12 days to approve it. And if they give it the green light, they then have to report that decision all the way up the chain to the central government. All right, so an order is issued and a person is taken into custody. What happens next? Well, the Act sets a really strict timeline for telling them why they're being held. From the very moment of detention, a clock starts ticking. The authorities have just 5 days to let the person know the grounds for their detention. Now, it is possible to get an extension up to 15 days in what the law calls exceptional circumstances, but the reason for that delay has to be put down in writing. Now, this brings us to a fascinating legal point. What if a detention order is based on, say, 3 different reasons, but a court later finds that one of them is invalid? Normally, that might make the whole order fall apart, but Section 5A of the NSA introduces this idea of severability, which means the order can still be valid based on the other legitimate grounds. It makes it a lot tougher to challenge. So, with all this power given to the government, what is the main safeguard for the individual? It all comes down to a mandatory review process, which is handled by a special group called the Advisory Board. And who are these advisors? Well, Section 9 sets a really high bar. The board has 3 members, and all of them have to be qualified to be high court judges. In fact, the chairperson must be either a current or former high court judge, which is meant to ensure a serious level of judicial oversight. And this whole review process moves fast. The government has to send the case over to the board within 3 weeks of the detention. The board then has to review everything and give its final opinion within 7 weeks of that original detention date. The board's report really comes down to one of 2 things. If they find there is sufficient cause for the detention, then the government may confirm the order and continue holding the person. But if the board reports there is no sufficient cause, the government's path is clear. It must revoke the order and release the person immediately. But here we come to one of the most critical and frankly controversial parts of the whole act. While the person who's been detained can appear before the board themselves, Section 11 explicitly says they are not entitled to be represented by a lawyer. Just think about that for a second. In this incredibly crucial review, there is no right to legal representation.
So what happens if the advisory board does approve the detention? How long can it actually last? Let's look at the ultimate limits and protections that are written into the law.
Once an order is confirmed, what's the maximum time limit? Section 13 sets a very clear ceiling. A person can be held for up to 12 months from the day they were first detained.
It's important to know, though, that this isn't some kind of fixed sentence. The government always has the power to revoke or change the order and release the person at any point before that 12-month maximum is up.
However, there's a big exception to that one-year limit. In areas that are officially declared disturbed areas, places where there might be significant civil unrest, Section 14A allows the maximum detention period to be doubled to a full 2 years.
And one final powerful provision to look at is accountability. Section 16 of the Act has what's known as a good faith clause. What this means is that officials are legally protected from lawsuits or prosecution for actions they take while enforcing the Act as long as they were acting in good faith.
So, as we've seen, the National Security Act sets up this really detailed legal framework for preventive detention. It grants pretty significant powers to the state, but it also tries to build in a series of procedural steps, deadlines, and a mandatory review by a judicial board. And all of this leaves us with a fundamental question, one that lies at the heart of so many laws like this around the world. How does a society strike that perfect balance between the needs of national security and the protection of individual liberty?